Hello and welcome to Writing HR's webinar on the top 10 frequently asked questions on TUPE, which is planned to take 15 minutes of your time. My name's Sharon Riley and I've been working for Writing HR since March 2010 in the capacity of manager for the Northern team of consultants. I have my own client base that I support, ranging from professional services to global IT companies. Prior to that, I worked as HR consultant for a broad range of companies in many guises and as an internal HR manager before. So moving on to the webinar itself, as a result of registering today to view this, you will also receive via email a frequently asked questions summary sheet, which is essentially in more detail than what we're going to go through today, as it does have explanations on each and up to 15 questions. You'll receive a copy of the slides, an overview of potential TUPE claims to be aware of, some TUPE commercial tips, and these will be on the end of the slides. And you'll also be able to access our free advice on any queries, which is via our free trial call, and the details of which will be given at the end. So the aim of today's webinar is for you to go away understanding the top 10 frequently asked questions on TUPE and how to deal with these. So in terms of objectives, at the end of the webinar, the hope is that you'll be better able to evaluate whether TUPE applies, which includes outsourcing, understand the practical process for TUPE, and identify the impact of TUPE on dismissals and changing employee contracts and working practices. So if we start out with the most important question in TUPE, i.e. does TUPE apply? So for TUPE to apply, there must be a relevant transfer. Hence, reading directly from the regulations themselves, that's either a business transfer or a service provision change. So a business transfer being a transfer of an undertaking business or part of an undertaking or business situated immediately before the transfer in the United Kingdom to another person where there is a transfer of economic entity which remains its identity, or a service provision change being that there is an organised grouping of employees which has as its principal purpose the carrying out of the activities concerned on behalf of the client. So if we put those regulations into layman's terms, there must be a UK business or undertaking capable of transfer, which does in fact transfer from one person to another, retaining its identity, or in a service provision change, a change in contractor where services carried out by one service provider cease and are carried out instead by another. And within this is essentially three different categories, so i.e. where activities are outsourced, activities are reassigned as part of a retendering process, or the client decides to bring their activities in-house. And typical examples of these are cleaning contracts, security contracts, catering contracts, as they essentially revolve around a client and a contractor. These two categories are not mutually exclusive and can be applicable together. So the key consideration here is whether there is an economic entity capable of being transferred. Regulation 3 Part 2 of the 2006 regulations provides that to satisfy this requirement, the undertaking must involve an organised grouping of resources with the objective of pursuing an economic activity, whether or not that activity is central or ancillary. So for example, a team of staff dedicated to a business or part of a business is likely to constitute such an organised grouping of resources capable of transfer. So for the purposes of transfers being covered by TUPE, for a business transfer, they must be located within the UK immediately before the transfer. However, for service provision change, they must be located in Great Britain, as service provision changes are not covered in Northern Ireland, as they are covered under the Acquired Rights Directive, European legislation, which does not provide for service provision changes under TUPE. And finally, TUPE does not apply to transfers by share takeover because the identity of the employer does not change. So looking specifically at service provision changes, there are certain key exceptions which tie in with the definition of TUPE, namely the principal purpose of employees is to service more than one client. This is because the provision of the service by the incumbent provider must involve an organised grouping of employees which has as its principal purpose the carrying out of the activities concerned on behalf of the client. This is intended to confine the 2006 regulations to contractors with a dedicated team providing a particular service. If there is no such identifiable team and the work is rotated around different staff, then TUPE will not apply. A single person can, however, be a grouping for these purposes. So the second exception is one-off contracts of short-term duration. This provision ensures that the regulations do not catch those cases where a client buys in services from a contractor in connection with a single specific event or task without intending to enter into an ongoing relationship with that contractor, and then subsequently buys in similar services from a different contractor. So for example, something like arranging a single conference would fall under this and obviously would be out of the rules of TUPE. So looking at a TUPE transfer outside of the UK, and particularly whether there is one where the transferee intends to carry out the same activities but outside the UK, current case law establishes that a transfer can take place in a different location as long as the initial business was conducted in the UK. So one of the key pieces of case law is Hollis Metal Industries Limited versus GMB and Newell Limited, whereby Newell had a manufacturing business in Tamworth, UK, and transferred part of the business to Israel. None of the employees moved to Israel and were dismissed by Newell shortly after. The Employment Appeals Tribunal stated that as the business was a UK entity at the time of the transfer, the employees should have had the right to transfer. Although there is this case law from December 2007, in practice there is relatively limited case law on this subject, as a situation is normally dealt with as a redundancy situation, and there would be a commercial agreement between the existing employer and the incoming contractor under which the employees are dismissed by reason of redundancy, and their entitlements are honoured using the incoming contractor's ETO of relocation as the rationale. So moving on to how we identify who transfers in a TUPE situation, the definition being that in order for an employee to be transferred, that person must be employed by the transferor and assigned to the organised grouping of resources or employees that is subject to the relevant transfer, i.e. employed by the transferor and also working in the part of the business to be transferred. In many cases, it will of course be clear whether employees are assigned or not, where however only part of the business is transferred and employees work in different parts of the business, this may be more difficult. As a rough rule of thumb, the figure of 50% is used to determine whether they transfer based on their working time. However, case law has ruled that this cannot be the only factor in consideration, and one Employment Appeals Tribunal has set out a non-exhaustive list of relevant factors to consider. These being the amounts of time spent respectively in the transferred undertaking and in other parts of the business, although as highlighted, a figure of just over 50% would cause initial concern if this was the only rationale. The amount of time given to each part by the employee, so for example, the employee perception of their work, or even something as simple as team names. Thirdly, the terms of the employee's contract of employment insofar as they establish what the employee could be required to do. So for example, does it fit with the work that's transferring? And finally, how the cost of the employee's services has been allocated between different parts of the business. So here we're sort of looking at salary cost centres, and these are key things that in your due diligence information you should be asking for copies of. So although with TUPE, courts have developed anti-avoidance approaches to prevent parties contracting out of TUPE, there are legitimate avoidance measures that mean whether as a transferor or a transferee, the requirements under TUPE can be avoided. So firstly, as identified previously, if there is no organised grouping identifiable at the point of transfer, then TUPE does not apply. Secondly, if the transfer of work is short-term or the run-off of work, i.e. the finishing off of a product within the next 6 months, which is usually given as a rule of thumb, then a short-term exemption can be applied which means that TUPE does not apply as the employees that may have been identified will not be engaged for long enough post-transfer to be covered. Thirdly, in many service provision changes, when a contract is re-tendered for, it is awarded to a panel of providers, and therefore the contract is so fragmented or shattered the individual transferees cannot be identified using the criteria discussed in the last question. An example piece of case law is regarding the provision of accommodation services for asylum seekers in Clear Springs Management Limited versus Anchors and Angel Services, which was an Employment Appeals Tribunal case in 2009. The contract was lost to 3 new providers. Clear Springs did not allocate employees to particular clients, and there was no discernible pattern of relocation amongst the new providers. So the Employment Appeals Tribunal confirmed the activity carried out by Clear Springs was so fragmented that no relevant transfer could take place. So finally, and in very few cases, it can be argued that the pre- and post-transfer activities are wholly different. An example of this would be the OCS Group versus Jones, whereby the provision of a restaurant serving hot food and deli bar was replaced by packaged cold food, and the Employment Appeals Tribunal confirmed TUPE did not apply as the services were wholly different. And as you can see, it is not as easy to say that a percentage of 50% identifies employees who will transfer. So moving on to commercial arrangements in avoidance measures for TUPE, and the question of whether a client can stipulate a contractor must not use a dedicated team of employees to avoid TUPE applying to reassignments. A client, when contracting out, may attempt to get a contractor to sign within a commercial contract a clause to ensure when the contract is reassigned as a result of a retendering process, the provision of services is more appealing and less costly by ensuring there is no organised grouping. And there is nothing in the TUPE regulations that will prevent an arrangement of this type. However, a contractor is likely to be reluctant to agree to such an arrangement, given if they do not win the contract back at the retendering process, then they will be left potentially with not enough work for the employees they have and a costly redundancy process and payout. The key question in this